Morning, Your Honors. The matter before the court this morning is the case entitled State v. Davis, case number 23 AP 351. Representing the appellant, Timothy Davis, is Brianna Hauser. Representing the appellee, the state of Vermont, is Arthur Brown.
Thanks very much. Good morning again, everyone. We'll hear from counsel for the appellant. Please introduce yourself, identify your client, and then proceed.
Thank you, Your Honor. Brianna Hauser on behalf of appellant Timothy Davis.
Thank you.
I plan to focus my argument on the discovery violation issue, but I'm happy to answer any other questions that the court may have. The narrow question before this court with respect to discovery is whether the trial court abused its discretion by excluding the late disclosed evidence as a sanction for the state's admitted discovery violation. This was an abuse of discretion because exclusion did nothing to prevent the state from assuming an unfair advantage over Mr. Davis, where it did not restore Mr. Davis's ability to prepare his defense based on that late disclosed evidence, which included exculpatory material. Reversal is warranted for that reason. Mr. Davis was deprived of his right to prepare and present a defense, most notably because he had no opportunity to impeach the complaining witness who testified at trial with her prior inconsistent statements that were in the late disclosed recordings. He had no opportunity to interview or depose the additional witness who was first disclosed the day before trial.
But counsel, wouldn't he have had the opportunity to do these things if he consented to the continuance that the court wanted to grant?
No, the court never said that it would grant a continuance. In fact, the court specifically found that a continuance would be unfair to Mr. Davis. It said that this was a misdemeanor charge that had been pending for some time, and the court would not be able to hear this case for another 3 months, which the court said was not fair to Mr. Davis to do based on the state's negligence in providing discovery late. And so the court declined to grant the continuance, and the state hasn't challenged any of the court's findings with respect to a continuance in this appeal.
But I did not read, other than the judge's comment about this is going to take 90 days, continuance or 3 months, I can't remember how it was phrased. There wasn't any real inquiry into that with the court itself, was there?
Well, there was. Those were the findings that the court made. What defense counsel had argued was that the only appropriate sanction in this case was dismissal, because the defense counsel also argued that Mr. Davis would be prejudiced by a continuance. And so the trial court was essentially agreeing with all of the arguments that defense counsel had made. In this case, the prejudice to Mr. Davis was that he was deprived of his right to prepare and present a defense. So the only sanctions that really could have provided any meaningful remedy were dismissal or continuance. And because the court found specifically that a continuance was unfair, it was an abuse of discretion where the court failed to grant dismissal.
All right, thank you. I appreciate that clarification.
So in its brief, the state engages in pure speculation in suggesting what the effect would be of the exculpatory material at trial. And this court should not accept the invitation to reweigh the evidence that was presented at trial, considering exculpatory material that Mr. Davis never had an opportunity to present. What's critical is, again, that Mr. Davis was deprived of the opportunity to use the late disclosed evidence as part of his defense because of the state's late disclosure and the court's failure to provide a meaningful remedy. So unless there are further questions, I reserve the remainder of my time for rebuttal.
All right. Okay, that's fine. Thank you very much. We'll hear from counsel for the appellee. Please introduce yourself, identify your client, and then proceed.
Good morning, Your Honor. I'm Arthur Brown. I'm at the Rutland County State's Attorney's Office, where I'm a deputy and I represent the state.
Thank you.
So I'll just move down my list here. The state has always acknowledged there was a discovery error here, and I acknowledge and apologize for that again today on behalf of the state. Having said that, my argument is that trial is a messy form of process. That is why there are rules like Rule 52. And there are frequently errors at trial or evidentiary errors leading up to trial.
I might, if I could interrupt you, I might take opposition to your characterization of a messy form of process, counsel, but I won't belabor it. But I don't agree with you about that.
I don't mean to. Yeah, I think I can understand Your Honor's point. This wasn't messy in the way that evidentiary objections are sometimes messy. But what I mean to say is that
Well, the word messy is really a very loaded word, and if you know, respectfully, I would caution you against characterizing a process that we have, you and us have worked very, very hard to make sure honors the the individual rights of the litigants. So I don't like the word. That's what I'm saying.
Okay. I think I say all of that as an introduction to the standard of review, which is abuse of discretion. And I think there is a reason that this court uses that standard to review trial court discovery rulings. The word messy is not an apt word, but there's an art, maybe is a better way of putting it. And there is room for multiple solutions to problems because it's difficult to craft a solution. It takes a knowledge of the parties, the circumstances, the facts of the case, the facts of the court, the administration of justice. So it's maybe difficult is a better word than messy, but it's a difficult thing to do, and the judge here did his best, and the state asks this court to defer to his ruling.
Thanks for that clarification. I appreciate it.
Yes, sir. So I'll turn to. I have 2 points here, 2 overarching points. First, the word prejudice is very important to this case. And when using broad terms like prejudice, which are broad, which are maybe vague, it's important to be precise. And the state's position is that appellant is not being precise in the use of that term. I think there are at least 3 ways that term is being used differently in this case. One of them is a more procedural way of use, which refers to being ambushed at trial by evidence, the existence of which you didn't know. That's not exactly what we have here. The state did disclose to an extent the existence of video evidence on a face sheet, which was produced. There's a checkbox saying video evidence described. Apparently, there was never any follow-up, but in any event, defendant did not have the video, wasn't able to review it. So there's an element of ambush. That is one form of prejudice. Another form of prejudice would be more substantive. What is the evidence? What would it show? And would it matter? That's a wholly separate type of prejudice. And then the third type of prejudice is hardship. And when I hear opposing counsel say the court found that appellant would suffer, then defendant would suffer prejudice by through a continuance. I think what the court meant was hardship. And so I don't understand that argument. I don't think the court meant prejudice in these technical ways. But with regard to those 2 technical ways, the state opposed suppression. The court granted suppression. That eliminated the element of unfairness or ambush.
You have 1 minute, counsel.
Thank you, Your Honor. With regard to ability to prepare or review the evidence or to consider ways to use it, the state asked for a continuance, and this court can consider in weighing the reasonableness of the trial judge's decision that appellant opposed that remedy, which would have allowed him more time to review the evidence. Thank you.
Okay. Thank you very much. How much time does the appellant have, please?
Appellant has 1 minute and 12 seconds remaining.
Counsel.
Thank you, Your Honor. With respect to the state's argument that the court's rejection of continuance as an appropriate remedy in this case is essentially meaningless with respect to this court's analysis. I think it's critical that the state never challenged the fact that the trial court found that a continuance was not appropriate in this case, and so there was no reason for defense counsel to argue with that, because that was the same argument defense counsel was making. So there is nothing more that I think that defense counsel could have done in that respect. The record here shows that defense counsel did not have an opportunity to review this late disclosed evidence with Mr. Davis until just moments before his trial. That was unfair surprise. It was ambush, and the outcome here is inconsistent with the purposes of the discovery rules and with Mr. Davis's constitutional right. And this court should therefore reverse Mr. Davis's conviction for this misdemeanor offense.
Okay. All right.